Good morning and good afternoon, everyone. Thank you all for virtually coming. Today is the second panel of this webinar series entitled Empowering Perspectives, Unpacking the Brazilian Industrial Property Law. I would like to thank you, the Young Scholars Initiative, for the realization of this webinar through the Finance, Law, and Economics Working Group, a group of which I'm part. I also would like to thank the Future Law and Lapia FRJ for the support they provide as co-organizers. And this webinar series is based on the book Comments on the Brazilian Industrial Property Law by Women, recently published by Thomson Reuters, which unfortunately so far has only the Portuguese version. Therefore, this webinar aims to bring some of these women authors to talk about the IP scenario in Brazil in the English language for national and international stakeholders. It was the first time that we had such a piece of work authored and organized by women in Brazil and maybe in the world. And therefore, it is also the first time that we have a webinar series exploring and following this path. Today, we are going to discuss trademarks, as the title of the panel is as follows: SheMarks, Exploring Trademark Possibilities in Brazil. My name is Deborah. I am an IP and competition lawyer and an expert in economic analysis of innovation and IP in the University of Hamburg, Ghent, and Pompeu Fabra, under a LLM program coordinated by the Erasmus University of Rotterdam, so-called European Masters in Law and Economics. Together with me, also moderating this panel, I have Flavia. Flavia, do you want to introduce yourself or should I?
Well, I can do that. Thank you so much, Deborah. It's impressive how, first of all, my compliments to you to organize this seminar. It's very important for us women and also to bring Brazil to the international perspective in a very positive way. So, well, I'm an IP attorney since 1997. So before that, I was an international and commercial law attorney. So starting with my my little steps in IP. So I studied in Europe too. So all my studies were done in Paris, in France. So also my master's and my PhD. I'm a professor here in a digital and IP environment and innovation in a School of Law of São Paulo, Brazil. And also I'm the founding partner of an intellectual property firm. So it will be a pleasure to be moderating this panel with my friends, that I could say. And it was a great pleasure to be part of this female author work. That was amazing and very, very updated. You're gonna love it.
Thank you very much, Flavia. All right, now we are going to move for the discussions. First, I would like to explain the agenda of the day. We have 2 expositions, 15 minutes each, and then with the remaining time, we will be taking questions. So please feel free to write down your questions through the chat here on the platform during the presentations, and we will read them timely. That said, I would like to introduce to you the first speaker of the day. Her name is Jessica Pinheiro Orazabal. I hope I pronounced it right. She is a partner and head of the international department at SKO Ozarbal, Trademarks and Patents. She has a Master of Laws and is a specialist in copyright and industrial property at the Federal University of Rio Grande do Sul, a program through which she conducted research at the Max Planck Institute in Munich, Germany, and she is the current president of ABAPSU. Jessica, the floor is yours.
Thank you, Deborah. I'm just going to share my screen to start. Okay. You can see my screen? That's fine?
Yes, perfect.
Okay, thank you. So thank you, Deborah, for this invitation and for having me today. It's a pleasure to be here, especially with my 2 other friends and colleagues, Flávia Mansur and Débora Barbosa. It's a pleasure to be here with you girls, especially as Flavia said, in an occasion that recently was published, a very important work. In my point of view, it means that is a progress regarding the publishing work in Brazil, in books regarding intellectual property aspects, not only because it was written by women, but also because because we have so few work published regarding comments intellectual property in our industrial property law. So that, and in this, the result of the success of this book is in the sold out of the work recently, even before the first launch that occurred in São Paulo. So I'm going to introduce myself so briefly. I am Jessica Pinheiro Yarzabal. I am from south part of Brazil. I am from state of Rio Grande do Sul, Porto Alegre, which is city that we can make a little translation means happy harbor. I am attorney at law, especially in IP. I started very young in 2008. And I'm just sharing briefly my resume just to highlight that I think my previous experience abroad could contribute for my point of view regarding intellectual property system in Brazil. So when I received the invitation from Professor Coni to contribute with this work, she proposed to me to write about the co-ownership regime, which is a brand new topic in Brazil, and what was very challenging because she proposed to me to write about facing the change of ownership and the updates regarding license agreements. And it was not only write about the chapter 11, but also and make comments regarding the articles 134 and 141, but also to analyze this in a critical way. So when I was informed before that might be people that is not so close with the intellectual property system. So when we talk, I'm gonna try to clarify some concepts during my exposition. So when we talk about co-ownership regime, we have to be in mind that co-ownership is a situation that you have more than one owner or application of a trademark registration or application. So in this situation, we have to think about the different interests that might occur between this co-owner. And they could not get in a consensus regarding the strategies of their trademarks. And when we talk about co-ownership regime, and this is and that's why I said it's a brand new topic. This was introduced in Brazil in 2019. And when you talk about co-ownership regime, we have to keep in mind the Madrid system. So this just occurred in implementation because Brazil became part of the Madrid system in 2019. And before, at the time, a trademark application would be limited to only one applicant. So an individual or legal entity will apply for one application and be one owner of this trademark registration. And when the discussions regarding the Madrid Protocol started, one of the points was that Brazil should attend some legal requirements, and that legal requirements, one of them was this regime, the co-ownership. At the time, the discussions started first if our industrial property law would accept this kind of regime. First of all, we have to keep in mind that our law was created in a time that the technology was pretty much different, and we have the environment right now. For example, at the time, the internet and the fax was the biggest technology that we have it. And of course, we could keep in mind that if this regime could be accepted. So one of the studies got the conclusion that our article 128 already preview the possibility to include one more of applicant or in a trademark application. So the article says that it's possible that persons, I am saying that in purpose, just to highlight the S of the plural, and legal entities can apply for a trademark application in the Brazilian territory. So based on that, as our law has as basis the Paris Convention and the TRIPS Treaty, we shouldn't face so difficulty to incorporate, to implement this regime in our system. In addition, our civil code already preview the possibility of multiple ownership for real estate matters. So which means that it could be applied for immaterial assets as well. Based on that context, we can the regime was implemented through INPE, which is the Brazilian Industrial Property Institute, which can regulate complementary, can legislate complementary, and they did this through a form or a rule, you can say, which is the rule 245, introduced this regime of co-ownership in the Brazilian trademark system. So based on that, when you're saying about based on that, last year a new rule came up, which is the rule 08 of 2022, that started bring the details regarding this regulation of this regime in the Brazilian system of trademarks. So when we're bringing this situation inside of changing the ownership in the trademark systems, we have a new environment, a new situation, where we have a group of people or a group of entities, legal entities that can transfer their trademarks. So they can be a big portfolio or only one trademark or few trademarks to a third party. That will be here in my example, the holder B1 or holder B2. And these requests have to be recorded at INPE. So INPE has powers to record these requests in their records. So we're gonna be in the after be approved, accepted, it's gonna be published, this acceptance. And of course, there is no certificate that will be published. So the trademark certificate, the new owners, they have to request this new trademark certificate. And I think the new challenges that this situation brings to us, and I think here very briefly I'm trying to talk about, is the new situation when you have to be careful with some tricks. When you especially when the holders, this group of holders, they have a big portfolio of trademarks and different interests to transfer these trademarks. For example, one of the points that, and this is connected with the law terms, which is the article says that when you have a group of trademarks, they have some features in common, especially in distinctiveness. This group should be transferred together under the penalty to be cancelled when we are talking about a trademark registration or archived, and we are talking about a trademark application. And moreover, this group of owners, the co-owners, they should be careful also about the authorization, because for this transfer happening, all the co-owners, they must authorize this transfer, or the attorneys. Of course, it's much better when this group of groups of co-owners, they have the same authority, they share the same authority, but this might not happen. Of course, it's not a general rule. The other situation that makes things a little bit more complex, when you can exclude one of the co-owners, or you can add another person. So when you have a big portfolio of trademarks, things can get a little bit more complicated, because sometimes we cannot do this in the same petition of request, and you should be very careful in order to avoid this cancellation or achievement of the trademarks. And advancing in the exposition, now talking about the license agreement. When we talk about this regime in the license agreement, of course, we are here facing a new situation where the co-owners can allow a third party to explore temporary this trademark, to use this temporary this trademark in the marketplace. And for this, of course, they, in order to avoid some problems with third parties, it's always recommended to record at INPEs. And of course, for the royalties payment, it's a quite an issue that you must apply, you must record at INPE system. So when we are talking about the license agreement situation, in a second time, you are facing different interests. For example, we have a group of people, a group of entities, they do not agree about the strategies about regarding the trademarks. They have different plans, they dream about different goals regarding their business. And of course, this can bring some challenges in order to make this licensing happen at the end of the day. And another point that, in my point of view here, it must be considered is regarding some formalities that in the past, in the recent past, was mandatory, and now it became more flexible, especially after the rules 25 and 28 that were implemented this year. And it was very interesting, in a parenthesis, during the writing of this paper, we need to have some updates, because the point of this book is to always make all the matters very updated regarding the topics of industrial property law. So in this scenario, the rule in general keep the terms of examination of a license agreement, but on the other hand, turn things a little bit more flexible, especially regarding the formalities. Now, imagine the following scenario. When you have a group of co-owners, they want to license the trademark for another group of legal entities or people, and they live abroad. So in the past, we had to send the draft, the contract, for these different parts of the world, and this keep all the process very long and very expensive in general terms. And nowadays, these rules introduced, especially this started last year in the beginning, the end of 2022 to 2023. It started some discussions at INPE to make this more flexible. Because of course we are facing a new situation in technologies. The business are faster. This makes the license agreements more attractive to run and to be close to finish the signatures. And of course, people have interests behind to make their business running. So going to finish my exposition here. And of course, is this invitation when the book is in an English version, probably in a close future. So to read it and then make, of course, your own conclusions. But in my point of view, of course, this regime introduced several new features in the trademark ownership and license. And this one hand brought a new scenario that made things faster and more attractive, especially when we're talking about different interests between the co-owners, even for changing the ownership to make transfers, or even for to sign license agreements. And this, of course, brought some impacts in the administrative procedures, which provides more flexibility, especially when we're talking about the signatures, the formalities regarding the trademark license. And this put Brazil in a puts the lights on Brazil in a way that this can bring more foreign investments. Can people feel more comfortable to contract between each other in a private perspective. And of course, this is a brand new topic, and I'm saying that considering a legal time frame, because was about yesterday, and we have a long path going on, and the outlines will be created, will build by the time as the practical situations will appear, raising and challenges to discuss this with INPE to improve this new situation. And here my final consideration is to think about if the actual law can handle these changes that reflects the changes from society. And I'm saying that because right now we are facing, recently because of the pandemic, we are facing TikTok, Instagram. 90% of the business here in Brazil are made by small companies and individuals that want to improve, to make business. And things are going faster. So we're not talking about one more than one. When I'm talking about co-ownership, you should realize that there are some partners that will not wait so long, some administrative procedures to be finished in order to make the business running. And another co-owner could be a little bit more cautious about, oh, we should wait, you never know. Brazil is not for people that is not unexperienced, because everything can happen in this environment. So I think we should make this reading about our actual industrial property law as well. Thank you so much for your patience and also for your time.
Thank you, Jessica, for your exposition. There is a lot to discuss on what you brought to us, and I'm looking forward to the debate right after Patricia's exposition. Following the agenda, Flavia, do you want to introduce Patricia?
I'm trying to find her resume here. Just a second.
I can introduce if you...
Yes, please go ahead. Go ahead.
Okay. Following the agenda, let's introduce Patricia Barbosa to you. She's a professor at the Academy of the Brazilian Patent and Trademark Office. She is also an examiner of geographical indications and trademarks, including collective and certification trademarks at the Brazilian Patent and Trademark Office. And she also has a PhD in innovation and intellectual property. Patricia, the floor is yours.
Thank you, dear. Hello, everybody. I hope you can see me, you can hear me, and also see my presentation. Please let me know if there are any problem. Is everything okay?
Yes, we can see it.
So let's go. It's a pleasure and an honor to be here with you today. I'm grateful for the invitation made by the organizer, Deborah Vicente, with whom I had the pleasure of writing about the subject that we'll talk today. Brazil protects 4 types of trademarks in terms of their nature, and I'm here to talk very briefly about the main aspects of the 2 most unknown natures, collective and certification marks. Let's start by talking about what makes these marks so different from the most classical, well-known individual marks, the product and service marks. First of all, collective and certification marks are marks with specific functions. While product and service marks serve to distinguish products and services from similar ones, a collective mark identifies goods or service originating from members of a specific community. And certification marks test the conformity of a product or service with certain standards of technical specifications, which may be linked to the presence or absence of certain materials, such as testing that a product does not contain pesticides. And another point that I'd like to draw your attention to is that certification marks are the only marks that have the quality function mentioned in the law. Because they have these specific functions, those marks must also be registered by specific owners. In the case of collective marks association, for example. In contrast, the applicant for a certification mark cannot have a direct commercial or industrial interest in the product or service to be attested by the mark. That is, an association of coffee producers cannot certify their own coffee as without pesticides. This is a guarantee of the impartiality of the certification marks process and methodology. And who uses these marks? In the collective mark, only associates can use it. Therefore, they are the only marks in Brazil that cannot be licensed for use by non-members. So non-members cannot use collective trademarks, only the members can. But in collective marks, the owners can also use the mark. Certification marks, on the other hand, are used exclusively by those authorized by the trademark owner. That is, the certification mark holder could never use his own mark. In order to be allowed to disuse, there are specific rules that must be followed by the interest. And these rules must be registered with the BPTO, the Brazilian BPTO. In the case of the collective mark, the rules are in the regulation for use, and the rules for the certification mark are in the so-called specific technical documentation. The absence of these mandatory documents is the main responsible for the closure of registration requests, always close to 75% in recent years. But why does this happen? The examination of the application shows that these types of marks are often applied for in the wrong way. There are many applications that enter with different documents as if they were the mandatory ones. It's very common to the applications come with the identity manual for the trademark and not the mandatory ones. In the case of this application, with this type of mistake, they are required to clarify whether they are in fact a collective or a certification mark. And mostly, around 95% of those who respond to this demand decide to change to a product or a service mark. As you may have noticed, those marks are used by several people or companies, and that is why they are called collective use marks, since the use is not only of the owner. But in order to use it, it's necessary to follow the rules of the regulation for use and the technical documentation that, in the case of the certification marks, must be controlled. For this reason, collective trademarks can be the marks that identify specific activities, such as service provided exclusively by women, for example, while certification marks can flag those that meet gender equity criteria, for instance. Due to these specificities in Brazil, only these trademarks have an extension of protection provided by law. The registration individual trademarks have 10 years of guarantee protection, but the collective and certification marks continue to prevent other registrations for another 5 years after its extension. It's an exception. And the certification marks has 2 more questions that I would like to draw your attention to. The first question is that Brazil does not accept registration of certification marks for individuals and process. Considering that nowadays professional certifications are increasingly common, this is a gap that Brazil law has with reality. The second question is about the distinctiveness of the certification marks. In them, differentiation is closer than what we might call, roughly, a brand club, where those who have the right to use it are distinguished from those who do not have. There is a line of thought which believes that in the short time in some markets, such as coffee, for example, certification will no longer be an option, but an obligation. Like coffee that does not have a mark attesting the control through certification will not be able to be sold. And that thought brings us to the next point. how our certification gain more and more value. Some research is showing that consumers are increasingly aware of aspects that cannot be perceived by our 5 natural senses, such as size and taste, for example. For this reason, more and more packages are full of seals with different information. Do you recognize of these symbols? So all of these often confuses the consumer. Symbols like these are made to communicate what kind of information. In this scenario, certification marks are gaining attention by communicating these belief goods that the consumer cannot fully guarantee either when they observe it or try it. The more consumers recognize the mark, the more easily he understands what is behind it. On these slides, I want to show you some of the certification marks registered in Brazil that communicate these attributes. The first mark is rainforest, which is one of the pioneers in the segment. Those other two here are from the certifier IBD, which has a series of marks aimed at different types of the called green products. It's one of the most recognized certifiers in Brazil and internationally. This third example is from a mark focused on gender equality, owned by one of the organizers of the book that gave rise to this webinar. Finally, we have the mark of a program of the Brazilian government, the Procel mark. It's used to demonstrate how much energy the appliance consumes. We are almost in summer in Brazil with very high temperatures. So if you don't want an unpleasant surprise with your electricity bill, it's essential to know how much energy your air conditioner is consuming. Not to mention that reducing energy consumption is a good thing for the whole world, being aligned with sustainability issues. Now, let's move on to examples of collective marks. And I'd like to show you how the specific function of communicating to the consumer that the product or service comes from a community can make them more attractive to certain market niches. This first mark indicates that in addition to being collective, the origin of the products is Brazilian. The second one highlights its origin is family farming. The third one from a group of Black women from the Cerrado, which is Brazilian biome. The fourth is used to identify a group of martial arts practitioners. And the last one is from products that were extracted from a protected national forest in the Amazon region of Tefé. Very briefly, those were the main points I'd like to highlight to you. I hope you enjoyed. I'm glad to answer any questions you may have. And if you want to know more, please read the book. Once again, thank you, Deborah.
Thank you very much, Patricia. It was a great exposition. I love these slides, by the way. Well, moving to questions. I think we are still seeing your screen, Patricia.
Oh, I'm sorry.
No, it's okay. Well, we can move to questions. If anyone has a question, please feel free to write it down on the chat. Meanwhile, I would like to start the discussion. I would like to address my first question to Jessica, if I can. Well, as we know, the trademark licensing contract is somehow very distinct from the regular civil contract that we have in so many ways, because it already brings a lot of obligations that are laid down by law. That is, obligations that the parties should agree, right? It's like they should comply. It's not something that they can or cannot do. For example, according to the LPI, there is the burden that the interested parties, they should, for instance, look after the trademark, actively avoid unfair competition by employing out-of-court notifications or starting administrative proceedings within the Brazilian Patent and Trademark Office. And they also should, for instance, commercially exploit goods and services that are in accordance with that title. So my question would be, from your exposition, we understood that the co-ownership regime for trademarks should increase transaction costs, right? Because we would have more parties related to a trademark, which would make it harder to reach an agreement about everything related to that trademark. For instance, agreements about business partners, or if we should pursue a legal action or not, and so on. So having that in mind, from your legal expertise, what do you think, I would like to know, what you would recommend, when you would recommend a co-ownership regime for a trademark, and when you would not?
Thank you, Deborah. Before answering, I also like it, but the Patricia slides, and after that, I'd like to know some tips regarding all the effects. It was very, very nice. Well, answering your questions regarding when we recommend, in my point of view, a co-regime or not, I think would depend on the strategy, depends on what the co-owner or the individual or the entity, the legal entity is looking for when they are starting a business, or if they already have a business, but they will join a new project and they have some interests that can be common or not. So first of all, I think in my point of view, we should understand what is the goals and the perspectives that they have for the future regarding this business, because when things started, everything is so beautiful, everything's so, I think it is in the beginning is a good way to already establish the limits and the rules that they could structure their business project together in a co-ownership regime. And I think this will not work in a situation that the business relationship, you can see by the starter that could not move for a long term. And in a previous situation, we already have now some situations that in the middle of the way, one of the co-owners didn't see so much going on in the close future, and they give up, and the other party want to keep the dream, but seems they didn't have another, she didn't have at the time another person to share the expenses, so she gave up as well. So in my point of view, sometimes when some administrative procedures, they take a little bit longer than expected, because as I mentioned about technology, may think so faster, and people are so exposed in social media, and they use this as opportunity to expose as well their business. Sometimes when there is a connection between the law, the running time of the law, and as well the real life, the real business time, sometimes things could not go in the way that is expected. This is my point of view.
Thank you very much. I see that Flavia has the hands up. You can ask your question, Flavia.
Yes, it's exactly on the same sense. I thought it was very interesting, the discussions about the different interests that all the co-owners have. And I was thinking about, although they do not forcibly have a connection, they are not in the same group of companies. I believe that the solution for that, I'd like to know Jessica's opinion for this common strategy, interests, that they're interested are not, or goals are not the same. If we could create like an operating agreement, like we do in the shareholders agreement, where we can provide like provisions such as formation and purpose of the idea around the trademark, like capital contributions, who will put money on this or that, like allocation of profits too, in case of licensing, what they're going to do. Deborah mentioned something very interesting. One of the owners are going to like force an unfair competition situation against third parties, where the sanctions or the burdens the group of people that were together to create this business are going to undercome. Managing, voting, who's going to be like the percentage of ownership sometimes. Although this agreement would not go to the PTO, sometimes it's good to have like an organization on how this would be applied in practice. I want to know if you've been through this situation and what is the practice in your opinion. Thank you very much.
Was for me, correct? Yes. Yes, we did have already the situation. And this is that you said is perfect because it was in my mind, but while I was speaking, the thought went go away. But anyway, I agree with you. I think this is a very good start to have an agreement. Even this will not be recorded at the INPE, but it's initial terms to establish the rules of the game, that we can say in this way, and establish what is the limit of this business relationship, what they expect, where the limits they can't be more flexible or not flexible. So I think I agree with you, Flavia. This is a good start, of course. Perfect.
Well, yeah, Juliana, do you have a question? Oh, no. Okay, I will follow up with a question to Patricia, if I can.
I'm sorry, Deborah, I'd like to make a question to Jessica.
Oh, okay, of course.
The first one, I'd like to know which was in your opinion, the most difficult adaptations that Brazil have to face with the protocol. And the second one is almost a joke. I noticed application, the trademark was the name of a pet. As you talk about TikTok, we also have a lot of business going on Instagram, and the pet market nowadays is getting even bigger and bigger. The pets are almost celebrities or more than celebrities. And I got an application that the trademark was the name of the pet. And I was thinking about if the owners of the trademark, the co-owners, was a married couple and they decide to divorce. It's almost a joke because the pet is now so getting such I don't know how to say, a high level that is not a good, it's pet, something alive. But how about your opinion about this too?
Okay, well, answering the first question, I think in my opinion, that I face it regarding the implementation of the protocol was the time on the prosecution, because on some point in the trademark procedures, some point was very good in the beginning, but of course by the time things got a little bit different since the beginning. But I thought that, in my opinion, Brazilian Trademark and Patent Office did very well handle the situation, because this was one of the legal requirements in order to be part of the protocol system, which was the time to examine a trademark application. Also, regarding this new situation of the co-ownership, because this is pretty much new, and I think this opened too many possibilities and discussions. And I think only the time, as I said, that will be able to define the outlines regarding this matter. And of course, I'm pretty much curious about the multi-class system. I know that is not still running yet. It's not running yet, but I'm very, very curious how it's going to be in a close future, I hope. at least. And regarding the second question, I have a friend and they passed through the situation, very similar. Yes, and she got married after this situation. So they share the pets, and she is a kind of influence in the vegan marketplace, but they are discussing this legally. I don't know what is the Flavia's opinion. I would like to hear as well, but the discussion in this case, of course, was not about the trademark, but I'm just sharing this isolate case that they were discussing first which tribunal, I would say that would have the powers to judge the situation. Because for our Brazilian law, this is classified as a thing. And of course, and regarding who, if I understood well, your question is who is going to be managing the trademark application, correct? It'll be one of the parts. So I think this is going to be very, very, very hard. As I said in the beginning, when you start a business relationship, especially when people are married, everything runs very well. But I think there will be some difficulty and some risks, of course, because when people are sad and we're talking about a personal relationship, even bad things can happen. And I can say, and I can think this in a hypothetical situation. For example, one of them can be bad and cancellate one of the trademarks. Can try do that. So I don't have the exactly the correct answer, but it was very good start to make these reflections. What, Flavia, do you think about it?
I think that, well, since the trademark is a property, you can treat it exactly the way the civil code treats. So exactly the way the real estates are treated. So they're both owners, so they can apply the same rules. Of course, there are some details that must be seen in the situation, but also if it's the same succession, it's the same, everything that it's applied in the civil code. Because trademarks are not autonomous from the whole legal system, so we have to apply other transversal rules to apply to certain cases. Succession, like corporate, also family law, and when you mentioned animals, I thought it was very interesting because the animals have rights, but they don't have personality. So the rules are, they can be owners. Sometimes for the Madrid Protocol, it could be an impact because in other jurisdictions, they have personality rights, but not in Brazil. But also the animals have rights, other kind of rights, such as right of life, to be well treated. You cannot do whatever we've done in the past, like not we, but some cultures like farra do boi or something. So you have to take care of those animals, like if they have certain kind of rights. So this is an advance of the society, in my opinion. And answering to Jessica's, I think we can use the civil code as an ally here.
Well, I would like to address a question to Patricia now, if I can. Especially from your expertise, Patricia, what are the main challenges faced in examining and assessing the registrability of collective and certification trademarks? For instance, in your practice, to analyze the certification trademarks, apart from the prohibitions outlined in Article 124, do examiners take into account any other point? What would you bring to us according to your expertise within the Brazilian Patent and Trademark Office?
Thank you, Deborah. As I speak very briefly, because I was very worried with the short time, the main difficulties to examine this kind of trademarks are the specific documentation they are required. For the collective trademark, there is a lot of things that must be mandatorily presented in the application. some topics that must be in the regulations for use. Some things like what are the conditions to use the trademark, who can use, who cannot use. And it's very common to see in this regulation of use that the mark can be licensed. And this is not possible by our law. So it's a kind of problem that we face in the examination applications. And also in the certification marks, sometimes there's another kind of problem. Because certification, they need to show which qualities or aspects of the product of the service will be certified. And he must show very clarify, make very clear to the others who will be reading, anyone, because any consumer can have access to this documentation. So he must speak very clear what are the aspects that will be controlled, how they will be controlled, and if it's really being controlled. So the certification marks have some rules that are very difficult to examine and ask a little more expertise to do it. Sometimes you got applications with so many pages, very big process, because they put so many things and you have to read it all to see if it's compatible with our law. And certification mark is a very specific mark. It's a very special mark, in my opinion, because it's the only one that the law says is responsible to attest the quality, to attest that the mark really means what he probably want to say he is.
Perfect, thank you. Unfortunately, we don't have more time for questions. We need to close this panel now. But I would like to thank you all very much for attending. And especially I would like to thank the time and the availability of Flavia, Jessica, and Patricia. Thank you very much, girls. It was a pleasure for me, and I hope to see you all very, very soon.
Me too. Nice to meet you, girls. Thank you so much, Deborah.
It was very nice as well. Thank you. Thank you.
Bye.
Bye.